Hello, this video is to provide you with an introduction and an explanation of the mediation process. This video is brought to you by Peter Taff, a civil mediator in Houston, Texas. Peter has 25 years of experience as a litigator and has participated in hundreds of mediations as a lawyer for plaintiffs and defendants. He now devotes his time to serving as a mediator of civil cases in Texas. Mediation is simply a process where the parties to a dispute come together with a neutral third party, the mediator, who works with the parties to help them settle their dispute. Typically, mediation is done after a lawsuit has been filed and the trial date is coming soon. However, it's not uncommon for people to mediate disputes early in the litigation process or even before they have filed a lawsuit. If the mediation is not successful, then the parties still have the ability to return to the court process and have a judge or jury decide the outcome of their dispute. The mediation can be done in person at an office or completely by video on a platform like Zoom. The process may begin with a joint session where the parties and their lawyers all meet with the mediator to go over the process and explain their positions. However, oftentimes, the lawyers and mediators will determine that an opening session is not necessary. In that case, the mediator will situate the parties and lawyers in separate rooms, either physically or virtually. The mediator will then meet separately with the lawyers and parties to confirm the background facts about the dispute. For example, in an injury case, that will mean confirming the parties' positions about the accident, the medical treatment of the plaintiff, the medical bills, and any other claim damages. Once the mediator has confirmed that the parties are all on the same page on the facts, he or she will then go back and forth to relay the parties' offers and counter-offers. Depending on the complexity of the dispute, the mediation can be as short as a few hours or can last an entire day. Even if the case does not settle at the mediation, most mediators will stay involved afterwards to offer assistance towards resolving the case. If the parties reach an agreement to settle, the basic terms are usually put into a short agreement. The lawyers will then work together to prepare a more detailed final settlement agreement. If the parties are not able to settle, then they can resume the litigation process. Everything that you or your lawyers talk about in the mediation is confidential and cannot be repeated to the judge or jury. Not all cases can be settled at mediation, but the vast majority do. There are several benefits of settling a dispute through the mediation process. Control. You decide and control the outcome and are not leaving your dispute to be decided by a judge or jury. Certainty. No one can predict with certainty as to how a judge or jury will decide your case, or when your case will be decided. A settlement at mediation provides certainty and finality. Timing. Many courts are backed up because of events like the COVID pandemic, so it may take a long time before your case actually reaches a trial. And even if you do win at trial, the other side can appeal and further delay a resolution. Costs. The longer a dispute takes, the more that litigation costs add up. By reaching a settlement, the parties stop spending money on litigation. Confidentiality. If the parties agree, then the settlement can be made confidential. We hope this video has been helpful and informative. We wish you the best towards resolving your dispute.